Welcome to the Tanya Acker Show. My next guests are four of the lawyers who were a part of the legal team that secured the $787 million settlement against Fox News on behalf of Dominion Voting Systems. They're here today to talk about defamation, when you should think about suing, when maybe you should let some stuff go. Chances are you have or will hear something unflattering about yourself at some point from somebody. Sometimes maybe the smartest thing is not to plot a pathway to the courthouse, but you can listen to Megan, Daniel, and Dustin and Andrew on that. We also talked about what happens when people make things up in court. What happens when they commit just brazen falsehoods in a court pleading or in a courtroom, because the remedies there are very, very different than they might be when people lie in other places. So here I am with Megan Meier, Daniel Watkins, Dustin Pusch, and Andrew Phillips. They recently just opened up their own firm in Washington, D.C., Meier, Watkins, Phillips, and Pusch. Thanks for being here. Don't forget to subscribe. Welcome to the podcast and congratulations on your new firm. Congrats, everybody.
Thank you.
Thank you so much.
Where does the line of this is my First Amendment right, my free speech right to say this thing, even if you think it's stupid, where does that line end and the line for defamation liability begin? Because I think sometimes people get confused. They think that the right to have an opinion means that you can share that opinion and say what you like wherever you like. Megan, elaborate, if you would, on where is that line? Help people understand where that line exists.
So we have a First Amendment that protects our right to free speech. It's a constitutional right. And I think the Supreme Court said it best when they said there's no constitutional value in false assertions of fact, right? So that's the crux that's the heart of a defamation claim, is a false assertion of fact. So you can have your opinion, you can say, I don't like the food at that restaurant. But if you say, I don't like the food at that restaurant because I found a dead rat in it, and you didn't, in fact, find a dead rat in it, then you could expose yourself to defamation liability if you cross that line.
Daniel, something else that I think a lot of people find troubling, especially people who aren't lawyers, is the extent to which people can say just about whatever they like. I know there are limits on this, but just about whatever they like in a complaint, and it's privileged. Can you explain a little bit to my audience about, one, why folks can say things in legal filings that may not be true, even if they know they're not true? And two, what's the recourse that people have? Because you can't sue somebody for defamation if they say something in a lawsuit that is false, but you do have some other options. Can you explain, my friend?
That's a great question. And we certainly want to be sure that people asserting legal claims are given a wide range of options in terms of making accusations in the context of pursuing a lawsuit against someone and pursuing damages based on those allegations. Now, in terms of recourse, if a lawyer puts something in a complaint that is false, then there are sanctions that are available. There are disciplinary actions from the Bar Association for the various states that they practice in. And so that's the real recourse. But it's very important that the legal process is protected. Otherwise, every time someone filed a lawsuit, they would be sued for defamation for whatever they put in their pleadings. And as officers of the court, we do our best to investigate anything before we include it in a complaint and follow all of the ethical guidelines related to that. But it is really important to protect that privilege in the context of court proceedings so that people are able to prosecute their claims.
And there's another. It's a rarely used mechanism, but some states do have what's called the sham litigation exception, and that's when you can prove that somebody put something in a complaint just for the sake of being able to try to get the protection when they knew it was false. And it not every state has it. It varies from jurisdiction to jurisdiction, but that's another recourse that may be available to some folks. But Daniel's exactly right. There is recourse, and it's in the form of part of it's us, not, having recourse for putting false things in filings. And that's actually a really important one.
I've had lawyers say to me that these days it's kind of like the Wild West. So there may be some officers, many, I think most lawyers, most people act in good faith. And there may be many, many officers of the court who do pay attention to those rules. But are you finding, and I'll throw this open to anybody, maybe you, Andrew, how often do you see lawyers actually taken to task when they or their clients cross the line? If you want to have a free and fair trial, you have to give people the freedom to make claims that they subsequently have to prove. But you all know as well as I do that there are plenty of people who know that you put something in a complaint, it's going to make press, it's going to get in the news, even before it sees a courtroom. And there's a lot of leverage in that. Do you think that with the rise of social media and all these platforms that it's just that people are becoming a little less careful about what they put in their court filings?
Oh, for sure. And I think I'm with you, Tanya, and I'm a little more skeptical of this privilege than my colleagues. I think the idea behind it makes sense, but it's kind of like a people can't have nice things situation. Like it gets abused. And when you know that you can put things in a court filing with impunity, a lot of lawyers take advantage of that. And, on top of that, you've got something called the fair report privilege, which means if it's in a court filing, now the media can report on it with no fear really of themselves being liable. And so they don't have to care if it's true or false. So I think kind of the double whammy of that, there's a lot of incentive to abuse it. And I think the worst part about it is that to the layman, maybe the non-attorney out there, I think it comes with sort of a stamp of legitimacy if it's in a court filing, even though I think most practicing litigators would tell you that something that's in like a civil complaint should most certainly not be taken as gospel. So I think it's unfortunate, but it is what it is as far as the law, and there's just an awful lot of protection for what's said in a court filing.
Can I give an example of this, Tanya, in a recent case that Daniel and I had? Daniel and I just represented a wonderful tech company called Every Realm that had terrible, terrible false allegations made against them in a civil complaint, really salacious allegations, one of which was that this ex-football player had been racially discriminated against because the company had deprived him of equity in the company, unlike his similarly situated white counterparts. The problem is we had his signature on the stock option grant where he got equity in the company, the same as everybody else. But this allegation goes into a civil complaint. It gets picked up by the news media. The company is racist. It was completely false, but a lie gets all the way around the world before, the truth can get its pants on. It's tricky in that situation. Then he went on Twitter and he repeated the allegation on Twitter, and Daniel and I sued him. And so that case recently settled because, you can't say lies on Twitter with impunity. You can get sued for what you say on Twitter if it's false and defamatory.
Well, let's go back to his claim itself. So you're talking about a situation where someone says, I didn't get this stock grant because of my race. It turns out they actually did get the stock grant. So before we even get to that person repeating the false claim on Twitter, they have a blatantly false claim as a core element of their case. Were there any repercussions to them? Were there any sanctions? Did anything happen as a result of that false statement?
The attorney withdrew that one allegation from the broader complaint, but the damage at that point is done, really, right? And so we were happy to be able to negotiate a settlement on this alongside our fabulous, fabulous employment counsel, who we work with all the time in New York. Once it's out there, it's kind of out there already. Once the press picks it up, they're not as interested in the correction as they are in the initial lie that made headlines.
I think Tanya, the answer to your question is, had he not put it out on Twitter, it would have been harder. And how that would have played out had that error not been made, it would be a little bit of a different story. I think you're absolutely right.
Your new firm is focusing on defamation cases, reputation management. And I got to ask you, and again, you all have experience with this. We know how quickly it is. I mean, you said it, Megan. A lie can travel the world before the truth gets its pants on. And while it's traveling the world, you get a whole bunch of people, presumably reasonable people, presumably thoughtful people who have busy lives, busy jobs, people who aren't going to necessarily do the research and do their due diligence on everything they read on the internet. So it's really easy for people to believe false things for a long time and for false claims, I think, to really take hold and to capture many, many imaginations. I mean, we've seen that over the past couple of years in our public life. What's the defense? I mean, how do you protect someone's reputation in an environment where you've got 10 people believing a lie, while they're still in the meeting with you? Someone comes to you and they say, so-and-so just put this out there about me. It's already got 100,000 views before our meeting's even over. Before you get to litigation, how do you counsel people in this kind of environment?
One of the biggest areas of our practice is you got to kill the lie before it gets published, right? So a big part of our practice is I get a call from general counsel of a Fortune 100 company. The Wall Street Journal just called us. They're about to print a story accusing our CEO of insider trading. They asked for a comment. Their deadline's in 2 hours. What do we do? And we answer, what do we do? How do we slow it down? How do we get the facts? How do we get the evidence and the people on the phone? And how do we help the Wall Street Journal understand they've been misinformed? They've been given bad information. Here's the right information. I'm not picking on the Journal. It could be any paper. I mean, Journal is probably one of probably our nation's top paper, or one of the top 3. I'm not trying to call them out, but that's what we do, is counseling and sort of working with reporters, and we partner with crisis PR firms all the time to try to help correct the story before it comes out. Once it comes out, what do? We try to get corrections and retractions, and if all else fails, the last resort is sue for defamation. That's the option here in the United States. In other countries, there are criminal penalties for speech. We don't do that here because we're Americans and we love the First Amendment.
The other thing is getting the truth out, right? Because sometimes the truth can be complicated, and what we do, working alongside PR professionals and crisis professionals, is getting our clients' affirmative story out in order to combat the disinformation before it's published or alongside such publication. I'm teaching a class this fall at William & Mary Law School titled Defamation and Disinformation that's tackling these very issues. It's complicated. We're hoping that some of the work we do introduces real risk to large companies that are in the business of publishing stories, so they take a second look before they go out and tarnish someone's reputation. Hopefully some of what we do is instructive to the readers so that it's easier to identify what's false and what isn't, but it's a challenge that we grapple with every single day.
And Tanya, I'm hopeful that recent defamation, high profile successes for clients in that area has created a healthy skepticism that don't, do your own work, wait till the facts come out, think critically about what you read and what you hear. Don't dismiss the news, but think critically about what you're hearing. And when counter evidence comes out, and look for counter evidence if it comes out, that there's now a little bit of a healthy skepticism given recent high profile cases. I'm hopeful that there is a little bit of the public thinking through this a little bit more. And I think that the more that people are held accountable for lies and misinformation, that will improve more.
We do, I think, as a country, we have some heightened sensitivities these days. We are a litigious place. And I think that there might be I've certainly seen situations where because it's so easy to tell stories about people, because everyone's online, because every social media platform, gives you space to tell a story about someone, and sometimes those stories aren't true. Do you think that because there's also such a proliferation of, let's just say, talking about others in so many places, that sometimes people have to maybe take a step back before that thing that they find offensive, or rather before they conclude that that thing they find offensive is actually something that they should consider pursuing in court?
I think that's a great point.
Yes.
How many times this week have you told clients not to sue for defamation?
We tell people not to sue way more than we tell them to
Probably
sue.
Yeah.
9 times out of 10, we say, okay, here's why you wouldn't want to sue for defamation. What else can we do? Sorry.
And there's something called the Streisand effect, right? If I'm falsely accused of something and I decide to sue someone for it, what's more likely than not to occur with most people is more people hear about the accusation and my lawsuit than knew about it in the first place. And so it's counterintuitive. And because of all of the challenges and hurdles related to the First Amendment, the different anti-SLAPP statutes, the cost of litigation, the length of litigation, et cetera, filing a defamation suit is typically not the answer for people. And we're the first lawyers in the world to happily say that to our clients.
And Tanya, you use the right word to kind of cull this out, and that's offended. I'm offended by something. And look, everybody is free to voice what they're offended by, but that's where we play, our profession plays a critical role in helping clients determine what is actionable. And that's a critical point to make, because a lot of people want to, hold people accountable for what they don't like, what they find offensive, or what they think is not nice to them or something like that. But we really do try to counsel our clients very carefully on what's actionable, what's worth their time from a legal perspective, and what they should really focus on in that regard.
Well, and Daniel made a good point, which is that because there's so much noise out there, sometimes better off, right? Just ignoring it, or just, letting it get drowned out by some other noise than you are by bringing attention to it, because then, you're actually giving the lie a story. Andrew, you told me a funny story before we started about someone who had some false statements made about him that he was very irate about, but you told him to take it down a notch and not go to court. I thought it was funny. Can you share that?
Yeah, so we were having a discussion of, what does it mean for something to be defamatory? And I like this story to illustrate the point that something can be false, but not necessarily defamatory. And the fact pattern was, I have a client, very wealthy individual, who was accused in a news story of parking his mega yacht near a certain tropical resort island. And he was very upset about this because he insisted, that's not my yacht. I don't own that yacht. I don't know why they're saying I own that yacht. And I had to explain to him, it may be false to say that you own a mega yacht, but it's certainly not defamatory because it's not negative. Any of us would love to have that mega yacht. It's certainly possible for something to be false, but not meet the legal definition of being defamatory. And that would be an obvious example.
It's like, somebody falsely said that I was 5'11" and on the cover of a magazine. I can't believe it. Like, kind of like that, right? Like that.
No, honestly, there's a perfect example of this. The My Pillow guy sued because a paper reported that he was dating the television star Jane Krasinski. And he says it's false. I'm not dating her. Well, she's a beautiful, accomplished actor.
He's my pillow guy.
He's so lucky.
Jane Krakowski.
What? How did I say her name wrong?
You said Krasinski.
I knew you meant. I do.
It's another famous actress. It's okay.
I botched it, but she's an incredibly talented actor, and I looked at this and said it's not defamatory to falsely accuse you of dating
a beautiful person.
Yes.
Moving on to really where we are today and where technology is, and the ability that all of us have to spread information about people, get information about people. That's really now in the palm of everyone's hands. And it's also now in the palm of the machine's hands because we're dealing with AI. And Megan, I know you spoke on this in the publication. We're now seeing cases where people are suing OpenAI because of the false information that comes out of ChatGPT. There was a radio host that's got a claim pending. Lawyers were recently sanctioned for using ChatGPT to write a brief. The brief had some bad cases. The machine just made up cases. The lawyers doubled down and were sanctioned as a consequence. Megan, where do you think, what role, I should say, or actually, let me ask the question a little differently. Where do you see the law of defamation going in light of these new technologies, right? If I'm a lawyer and I go to ChatGPT and ChatGPT pulls up a bunch of information, isn't it reasonable for me to rely on that a little bit?
I don't know if I see it going here, but this is where I hope it goes. I think lawyers should be able to use AI technology to get a first draft. I think journalists should be able to use AI technology to get a first draft. But we all now know that ChatGPT is a facially unreliable source that makes things up. We know that. And under the existing law of defamation, if a journalist blindly relies on a facially unreliable source and publishes it to a global internet audience without having fact-checked it and corroborated it, that is circumstantial evidence of actual malice that can subject them to a defamation claim. Actual malice means, did the publisher know or recklessly disregard that this was false? And what I would say is, if you use ChatGPT to write your article for you and the publisher pushes it out there without having a journalist and a fact checker go and corroborate it, I would say by definition that is a reckless disregard for the truth and should subject that publisher to defamation liability. I want to say something about that OpenAI case, the defamation case against OpenAI. That's actually an example of the journalist doing exactly what we need journalists to do. So in that case, a journalist got this information out of OpenAI, and then the journalist did what journalists are supposed to do and fact-checked it. And the journalist prevented that from being published out there to a global internet audience. That's what I want to see. And I want to see I've heard scary things about people saying, let's give publishers of OpenAI content immunity under Section 230 for AI-generated content. Imagine this. Imagine we do that. And you have two blogs. They own a bunch of professional, they employ 10 professional journalists. And you now say to them, hey, you can be sued for what your journalists put out there, but if you fire all your journalists and rely on AI-generated content, then you can't be sued for defamation. That giving immunity for AI-generated content being published out to the world on the internet is terrible for journalists. It's terrible for journalism. It's terrible for the integrity of our public debate. And it's terrible for the fabric of our democracy. So I urge your viewers, do not support immunity for publishers of AI-generated content. Fine to use it as a first draft, journalists. Fine for lawyers to use it as a first draft. But we know it's not reliable. You must fact check it before it goes any farther than that.
And I think that's really a key point. The machine, I like to call AI the machine, it hallucinates. Yes. My niece once did like a search. She did like a ChatGPT on me, and it literally made stuff up that I've never done. It had me teaching places I've never it makes things up. And so to your point, since we know that, then perhaps that reliance on it is reliance on it isn't reasonable without a human backstop. The case with the lawyers, though, I think poses another interesting issue if anyone cares to comment, because there it seems these lawyers use ChatGPT to write a brief. And some of the cases that the machine found were not indeed real cases. And when questioned about it, the lawyers doubled down. And as I understand it, the reason they were sanctioned is not because they used ChatGPT. They were sanctioned because instead of double checking, they doubled down. So as opposed to other legal platforms, right? Like if we look up cases on Lexis, I don't find a case on Lexis and then go to a law library somewhere and read a book like lawyers did in the old days. Like we can rely on the cases that are pulled up on Lexis, but not so with ChatGPT, correct? Like lawyers, you got to site check those cases.
I think that's right. I think that also it was truly a matter of first impression, right? For how a judge was going to deal with that. I wouldn't be surprised if going forward, if there wasn't this second level of protection, if a lawyer did that again. Given how high profile that matter was, and I'm sure that judges across America were familiar with it, the idea that a lawyer would get away with doing that in the first instance, I think that it's a matter of time where that is going to be sanctionable right off the bat if it's proven that a brief was done entirely through ChatGPT and no basis to believe there was any quality check or fact check or cross-referencing of anything. I think that now that we've had the first impression case, I think that you're going to see judges crack down on that in the first instance even more.
Can you guys?
I hope you're right, but I don't think you are.
You don't. You don't think so, Megan?
I have faith. I'm the hopeful one.
He is. Andy's our Eeyore, and Dustin's our hopeful one.
Can you all imagine if, like, when we were young?
You get paid by the hour. Why are you using a chatbot to spit out a brief? It doesn't make any sense.
Right, but this is. I've been saying this. The billable hour is going to be over within 5 to 10 years because of this. Because the technology is getting so much better, so much more quickly. I mean, it's right. And so I think you're going to see. I think it's only a matter of time before lawyers are able to 5x their efficiency. You get your first draft done right away, and then what the talent that you have is in editing, in checking, in knowing the right strategic move to make. But like waiting around for hours and hours for drafts of things, I think we're have to grow or die. Like I don't think the billable hour is going to be with us a decade from now. I don't think people are going to work less. I think we're going to be able to deliver more value for clients in the amount of time that we lawyers are inclined to work. And I think it has great implications for access to justice. For example, we turn away clients every week because they have a great defamation claim, but they don't have millions of dollars to litigate a case. It costs a ton of money to litigate a defamation case correctly. And I think if we can 10x our efficiency in like grinding through document discovery, grinding through first drafts, and like get to the heart of things faster and try more cases, I think we can take more cases on contingent. You can take cases on contingency. You can help the average person who is smeared in the media and not just the elite and Fortune 100 companies. I'm really excited about what we're going to see in the next decade because of technology enabling us to get more work done more quickly.
Well, the other thing that I would say, I've heard stories, I'm very young, I'm 35, but I've heard stories about typewriters and dictaphones and all sorts of manner of word processor technology. And there are similar types of arguments being made about what happens to the billable hour once we have PCs. And relatedly, spell check is AI. Autocorrect is AI, right? And so AI is a tool that we shouldn't be afraid of. We should view it as a way to enhance the deliverables that we can bring to clients. And that's what we try to do, but we're certainly not blindly relying on things that we pull off the internet.
Right. We need a human backstop. Daniel, you've got a really interesting case pending against McDonald's. Tell us about it, if you would.
No, that's right. So there's a company called Kitch that invented the fix for the notoriously broken soft serve machines at McDonald's. I'm embarrassed to admit how many times I've tried to go to McDonald's and get a McFlurry, and it never seemed to be working. But Kitch engineered a way to fix those machines. And a short time after they were really picking up momentum from McDonald's owner-operators, McDonald's came out with a false statement accusing Kitch's device of being unsafe. And that false advertisement drove them out of business. And so we filed suit against McDonald's and the maker of the machine. We've had a lot of success during that litigation, including a temporary restraining order and a preliminary injunction. And so we're really looking forward to continue to hold them accountable and deliver a great result for the client.
So I don't understand. What was their basis for saying it didn't work? Did it not work sometimes, or were they just doing, in your view, that thing that we say people do, which is let's just go with something that's not quite true? What was their basis?
So in terms of the soft serve machine itself, is that what you're asking?
Like what was their basis for saying that this device of your clients didn't work?
It was unsafe. Yeah, I really have no idea. I've been trying to figure that out for 2.5 years, and we haven't gotten a satisfactory answer. At bottom, it comes down to unfair competition, and the Federal Trade Commission is looking into it for anti-competitive practices. But that's really why we brought the suit, because there's no basis for the claim that Kitch's device was unsafe.
Are you going to put McDonald's out of business, Daniel? Is that what this is coming down to?
I can't comment on that.
And Andrew,
I hope when we win that case, we get a McFlurry machine in our new office.
Guaranteed.
not going to get one. I don't think they're going to give you one. Andrew, you told me about an interesting Privacy Act matter that you have pending against Fox. Tell us about that.
Fox not actually the defendant, they're a third party. So in a Privacy Act suit, you are suing the government for the release of protected personal records that may exist in a government database. So my client is a university president in Arlington, Virginia, who some years back was the subject of a federal investigation that ultimately resulted in no charges whatsoever, let alone a conviction. But what appears very likely to have happened is one of the investigators who wasn't happy that the case didn't proceed farther elected to try her in the court of public opinion and leak her protected personal documents to a reporter for Fox News. So as part of that litigation, of course, if you depose all the government folks and all of them swear up and down it wasn't them, eventually you need to go to the reporter and say, all right, who was it that told you this? And so we reached that stage. The Fox reporter refused to disclose her sources. So we had a whole lot of briefing about the journalist privilege and its application in the Privacy Act context. Just last week, got a great ruling from the federal court in D.C., ruling that my client has overcome that journalist privilege challenge and is now entitled to depose that Fox journalist. So it's, those kind of cases, and, they illustrate kind of where we started this discussion, the dichotomy of free speech and where does it end? And, certainly, a reporter's ability to obtain information from sources, has some value. But on the other hand, the Privacy Act itself is an affirmation that government agents leaking information about civilians to damage them is itself morally and legally wrong. And so, those two can come into tension in a Privacy Act case, and that's where we are.
What was the sort of information that was leaked about your client?
It was things like photographs, immigration records, naturalization forms, those sort of things, all of which, the government has, but they're not allowed to, hand out to journalists.
The court found, the judge in this recent hearing you mentioned, found that there's no privilege, the journalist isn't protected by the privilege from having to disclose her sources. So what's the next step? She'll be deposed and then asked at that time who the sources were, at which time she'll decide whether or not she's going to comply with the court order?
Yeah, that's correct. She is under a court order to sit for a deposition and divulge that information. And if she elects not to, she may well be subject to contempt proceedings. And we'll cross that bridge when we come to it. I would hope that she does the right thing and tells the truth, as she's been told to do by a court.
If she doesn't, then will you file the contempt?
I would think that's very likely. But, again, we'll cross that bridge.
Cross that bridge. You're not going to tell us now whether or not you're trying to send folks to jail for not complying with court orders. We're going to cross that bridge when we come to it.
I just want people to tell the truth. I don't want anyone to go to jail. So let's hope that's the outcome.
Wow, what a political
I was
answer.
like, actually, I want people to tell the truth, and maybe some people should go to jail, but we'll You four are phenomenal. Congratulations on your settlement. Congratulations on your brand new firm. And I wish you all the best. Keep protecting reputations and keep holding liars accountable.
Thank you so
Thank
much.
you so much.
Thank
Tanya.
you. Nice to meet you.
But